All right, welcome back to the Sandler Law Podcast. My name is Theodore, or Tuvia Sandler. I'm the managing partner of Sandler Law PA, a litigation firm in Miami. Today I'm joined by Tim Wan. He's the CEO of Smith Corrode, and welcome, Tim.
Thanks, Tubi. I appreciate it. Yeah. The name of the firm's a mouthful. Smith Corrode One and Parikh. We're a division of the One Law Group. We do collections, general counsel, business law, intellectual property, and a bunch of contract stuff up here in New York as well as Connecticut.
Right, so we talked a little earlier. You started off in New York and then you moved over to Connecticut recently, right?
Yeah. Yeah, we expanded there. I was admitted to New York as an attorney in 2000. I took the bar exam in 2000. Um, Passed first time, thankfully. And then after, 25 years of practice, we realized we had a lot of clients in Connecticut. I guess the border between New York and Connecticut's right there. So, we had situations where we had multiple parties or we needed a footprint in Connecticut. So both an associate and I got admitted there about a year and a half ago, 2 years ago.
Okay, cool. So did you move your office or you're just
No, we're
still?
still on Long Island. The office is out here in Smithtown. We actually bought this building in 2022 to move the firm out here. So we're in Smithtown. Connecticut does not have a bona fide office requirement, but we do have a location there if we ever need to do. I have a client who will let us use that space if we ever need that space for anything. But Connecticut is very much virtual and electronically filed.
All right, nice. Yeah, so how'd you get into collections to begin with?
Oh, okay. So now you're asking me my favorite topic, which is me. So I actually didn't want to even be a lawyer. Didn't want to be in collections, and I'll tell you the history. And hopefully your podcast audience will be entertained by my story. Is I wanted to be an actor. When I was in fourth grade, I got the lead in the play, and it was big musical theaters around the world in 80 days. And I remember standing on stage and getting a standing ovation because that's what you give 9-year-olds, right? That's what you give them. You get a standing ovation. But I remember standing on stage going, "Ooh, I like this." So I took 12 years of voice, 12 years of acting, went to college for music and theater, wanted to be on Broadway, wanted to be famous, and then gave it a shot. And a couple dozen auditions later, I had nothing, not a callback, not a part, nothing. And my grandfather looks at me and goes, "Law school or business school?" So I went to law school. Um,
That
went,
was it? Yeah, you
yeah,
know, you
went,
were.
well, I gave it a shot, and I failed miserably, right? I mean, it was also the '90s, the early '90s, and I don't necessarily know that a fat Chinese guy from New York is going to make it in on Broadway in the '90s. Now things are different now, right? In show business, things are different now. There's a lot more diversity and a lot more options. A lot more content out there, right, with all the streaming services. But back then, there was only certain areas that you could be in show business, and I didn't make that. It was a one in a million shot, and it wasn't. I was one of the 999,999. So my grandfather basically said, "Go make your pick," and I went to law school, and I cut my teeth doing entertainment law. So I worked at HBO and Island Records, Palm Pictures. Um, did not love being on the corporate side of things, so I flipped to the artist side, where I represented artists and musicians. So I'd hang out in bars in New York. I get bands press kits and CDs, and basically try to shop around, get them record deals. I do their copyrights and band agreements and things like that. But I like to eat and I like to pay rent. Can't do those things representing artists. So I came running back to my parents' house on Long Island, looking for any job I could find because I had, piling up student loans and not a real job. So I found a firm called Smith Corrode, with had a bunch of other partners behind it at the time, and I said, "Wow, it's 7 minutes from my house. I'll get a job there and figure it out. What's it do? I don't know. Collections? What's collections? I don't know. I'm gonna get a job there and pay some student loans and see what happens." And that was 25 years ago. So, but we've expanded the practice. So we started obviously the core competency, the bread and butter is collections and collections law, but that really stems from so much, right? It stems from breach of contract. It stems from having the right transaction in place. How many times do we get phone calls in the collections business where someone's like, "I want you to sue this person. They didn't pay this Trump promissory note," or I want to sue them for this, and there's no contract in place. The contractor's contract is unenforceable enforceable, or there's a venue provision or an arbitration provision, and now they can't do it. So I
Right.
shifted the practice to not only include that kind of litigation and collections law, but I shifted it to also include counseling clients from the outset to make sure that things are set up and enforceable. Because just because the internet says it or just because a textbook says it doesn't mean it's actually the way it should be done in real life.
Right. So how many attorneys at your firm now?
We have four attorneys, a couple dozen support staff um, that come and go, and we have a smaller, the team changes size as the years go by, and we currently have several people out, someone on maternity leave, medical, things like that. But I'd say we're roughly 20 people, roughly.
All right. Yeah. Nice size.
Yeah,
And you do everything, commercial and consumer, right?
that's right, commercial and consumer. Obviously we have certain people in the office who are dedicated to the consumer practice, and some people dedicated to the commercial practice.
Okay, cool. So what I wanted to talk about today, and in addition to kind of interviewing you, is just kind of pitfalls in collections. I've been doing collections for a decent amount of time, but you can always refresh and get
Yeah.
some insight from the veterans. So, um, just before kind of getting into specifics, what's the number one mistake you've seen made, and how do you avoid it?
Venue provision, exclusive venue provision. So, you know what I'm talking about, where the contract says any disputes shall be governed in the state of New York,
Right.
right? And then you've got your client who's in California, and the creditors in California and the debtors in Florida, and it has an exclusive New York provision.
So you're right. I mean, so that's really talking about from the outset of drafting the contract before the
Yeah,
credit is even created. Yeah.
yeah,
No, I
yeah.
mean,
Well,
but
that's a fatal error.
right, right. From the client's perspective, I mean, I guess that's really the second part of your practice, which is getting ahead of things before it even starts.
Right, right,
Yeah,
right.
yeah,
I would
but
say that's the biggest pitfall. I mean, because you see it all the time with that venue provision that boxes you into certain places, or even let's say it's not so distant, right? Let's say the creditor is located in New York, but they're doing business all over the country. So now they're selling to people wherever they may be. Let's say even worse, they're selling to a consumer, and let's say that consumer's in Jersey, right? But now, as we know, the Fair Debt Collections Practices Act, the FDCPA, says that if you're suing a consumer, it has to be done in the county where they reside.
right. So
Okay,
what happens then? You're just stuck.
you've got an unenforceable contract
Oh, wow.
because you can't sue it in New York because that'll violate FDCPA and it's going to get you sued. But if you sue it in Jersey, any attorney worth their salt can bring that motion to dismiss and say, nope, this contract can only be adjudicated in New York.
Right.
So
Wow.
what are you going to do?
Okay, interesting. I haven't
Don't
run
have an
into.
exclusive clause in your contract.
Yeah. No, I mean arbitration. I've run into that a lot, which is also. I mean, arbitration is beneficial in some contracts. Commercial contracts, big commercial contracts, is beneficial, but for smaller contracts, it doesn't make any sense.
Doesn't make sense.
Yeah,
I think
because
arbitration is very useful when the parties may still do business together or want to do business together, and maybe they're in the middle of a project, or maybe it's a large scale, like you said, a contractor, and there's a dispute between a subcontractor and a general contractor. Right, that would
right,
be arbitration because it's much faster than litigation. But when people say, "Oh, arbitration's less expensive," it's not when you're on a contingency fee basis, right?
right,
A lot of attorneys who've drafted that mandatory arbitration provision don't realize or don't understand that we, as collections attorneys, are legit attorneys. We're not an agency, right? Agencies are great. They do a lot of great work. They do very important work. But as an attorney, we are doing collection law on a contingency fee like an agency would. Therefore, you're not paying us hourly. And some of the attorneys that recommend arbitration don't understand that there's a dollars and cents difference to that, where you've got to pay four, five, $10,000 to file an arbitration,
right,
and now you're paying the arbitrator on an hourly basis as well, right? Because
right,
if you're
exactly.
paying the now and we all know that if you're paying an arbitrator hourly, their motivation may not necessarily be to expedite and accomplish the solution or accomplish the conclusion as quickly.
Yeah, yeah, that's a good point. All right. So how about once you're into litigation itself? Let's say forget all the venue and everything. What kind of pitfalls do you see within litigation, and how do you avoid them?
Well, I think from our perspective is keep your eye on the big picture, right?
What do you mean by?
Um, we're on a contingency fee basis. The majority of what we do is contingency fee, right? We don't get paid unless we've collected. Um, the attorney on the defendant side has every interest to drag it out as much as possible as they accrue their hourly rates. So when I say take a look at the big picture is how do we resolve this and how we get the project, how do we get this project to the end point? How do we get this case to its conclusion without being sucked down into years of litigation and discovery that's essentially erroneous or extraneous?
Right. Okay. So, I mean, that kind of cuts both ways, right? The defense attorney, it kind of depends what kind of attorney they are. If they're out in it for themselves, then yeah, they want to drag it out and bill as much as they can. But if they have their client's best interest in mind, they'll also want to just cut to the chase and just get it done.
Or they'll try to knock it out with a motion to dismiss.
Yeah. Right. Yeah. Motion to dismiss. But I mean, I like to think that in these situations, attorneys can see that there's a debt and it's got to be paid one way or another. Um,
I wish more attorneys thought that way.
yeah, no, you're probably right. Um,
I would say that. And I would say the other big pitfall that I see are people that think they can dabble.
hmm,
Um, you know, what we do is very technical. And to not have the right form, not have the right template, and to just kind of scattershot it is something that I can find dangerous because there's exposure there, because there is government oversight, especially in consumer collections.
right.
Um, but even commercial collections, there's actions for deceptive business practices and things like that. So I think that it's not just fire off the lawsuit and see what happens. And I think
Mhm.
that's the pitfall. Um, I would never try to do a personal injury lawsuit. I don't have a clue how to do that. It's got to be very fact based. I don't know the burden of proof. I do know it for collections, and some people don't. And I think that's another pitfall is they think, oh, anyone can file a lawsuit.
Interesting. So, in consumer, that's well known. FDCPA, got to be very careful with contact, communication, et cetera. But even in commercial, I mean, you're in Florida. There's the FDUPA, which is Deceptive and Unfair Trade Practices Act.
Yep.
So you've seen that as kind of a counterclaim or a defense.
Or sword instead of a shield in New York. I've seen it where I've seen law firms get class actions against them because of deceptive business practices.
Because of the way they're litigating their cases.
Right.
Wow, interesting.
Not having the right documentation and yet firing off a lawsuit.
Mhm.
Um, and we're talking commercial, right? We're not talking about consumer, so there's no FDCPA to rely upon. But you're basically run the line of frivolousness, right?
Mhm.
And that's what I've seen. I've seen some firms really get themselves bogged up into trouble by just firing off lawsuits, by not doing their due diligence, even if it is commercial.
Right. Okay. So, I mean, I don't think it's anything elaborate necessarily in diligence. It's just basically checking that you have a real credit here and that it's documented, right?
That's right. That's right. That's right. But there's a lot of clients out there who send you an invoice and go, here it is. Here's what I got. Or worse, a spreadsheet.
Mhm.
Here's a spreadsheet of my cases with the balance that's owed. Do you have the right party? We don't know that. You check in the Department of State to see if it's the entity name is correct.
Mhm.
That's the pitfall that I mean, if you want to segue into that, that's the other big pitfall I see, especially from out of state attorneys. They'll go after Joe's Pizza. No offense if anybody out here listening is actually Joe's Pizza, but you see Joe's Pizza, it's probably not Joe's Pizza Inc. It's probably under, if his name is Smith, it's probably Smith Holding Company or something like that, right? Smith
Mhm.
Holding LLC, right? Or Smith's Enterprises LLC. It's definitely not going to be Joe Pizza, right? So now you've got an attorney who, whether they're in state or out of state, fires a lawsuit against Joe's Pizza. Turns out there is no entity by that name. They've spent all this time and energy to get a judgment against an entity that doesn't exist, and then they
Okay.
go, here, enforce it. Not you, of course, but a Florida attorney files a suit. They're admitted in New York, but they're not up here in New York. They file the suit against someone, some entity that doesn't exist. Or the worst thing I see is that the address is it's a virtual post office at a national brand that has mailboxes.
I don't even understand. So, what happens? How do they even serve if it's not a real entity? How do they even
So
serve
in
the
New
defendant?
York, you can serve by the Department of State
Okay.
as your agent of service. And if the Department of State's listed address is that PO box or that mailboxes, right?
Mhm.
That
Yeah.
mailbox, that will be deemed proper service.
Mhm. Wow. Okay.
Sure,
Uh,
deemed proper service.
mm.
But do you have anything to go on? I don't know. It's It's a risk that you take. Now, are you so if you're the attorney representing the creditor, are you doing your client a disservice?
Yeah, of course. I mean, suing the wrong person, you're getting a
Right,
worthless judgment.
right, right. Yeah,
Wow.
I mean, how many times have we heard a client saying, "Did we win?" Yeah, we can win. We can win all day, but collecting the money and winning are two different things.
Yeah, a judgment is just where it starts in many ways.
Right. I've often joked that I have enough judgments uncollectible that I can wallpaper my house 5 times over. Of
Yeah, exactly. Certainly have a few of my own. Um,
course.
so what about just as far as drafting? Like down in Florida, we have some kind of quirky things like a judgment has to say specific words, for which some that execution issue forthwith, that sort of thing. Do you have
Yeah.
similar things up in New York? And
Yeah, there's all those very specific, peculiar things, and so that's one of the things that we do in our office is we train our staff to basically be specialists at that sliver of the law that they need to know.
mhm,
Uh, so we don't have remote employees because we work more like an assembly line.
mhm,
I know there's a lot of companies out there that work very well remotely. We don't. We don't. I when people ask me why, I give them the analogy that it's like, all right, if you were going to go buy a hamburger, would it be effective and would it be a tasty, well-produced hamburger if you had one person in one location making the bread, one person grinding and forming the patties, one person frying the patties, one person cutting the tomato, like in different locations? Is it going to be a very good burger at the end? No, it's probably going to be a little haphazard. That's how I feel. It's literally an assembly line with the documents that move throughout our office.
mhm. So it's just interesting to hear that. So when you put a case to litigation, you'll have like one staff handles the complaint and the summons, the next one handles what, or how's it kind of
Oh
work?
yeah. I'll do you one better. When we get a new case, we have one who's doing a demand with a different person doing the background investigation,
Mhm,
skip tracing and doing all and verification. And then I have a third person scrubbing, checking bankruptcies, checking that. So we have three people go in parallel. Once that all goes, they're only doing that sliver of it. And then at some point, if the demands fail, and we have located the person or party or the business, then it will go to a senior person to recommend a lawsuit.
mhm.
And then it goes to a different person to draft the summons, which is a different person that drafts the complaint. Because the summons is technical, right? You need magic words.
Yeah,
The complaint is theater
right.
because you're persuading from the first moment. So I see it as two different skill sets.
Wow. And then, so what about
And
within
then a different
litigation?
person files it, and all they're doing is filing. And then once we get that index number back, it goes to a different person who then sends it out for service of process. That's New
Okay.
York, at least.
Sounds like quite an operation.
Yep. So literally, the paper moves down the road, and we
I
spent
wa-
time configuring even the flow of cubicles, right? So like all moves in an order as opposed to crossing around.
so what kind of volume are you doing? I mean, if you don't mind telling me.
Yeah, we have 83,000 open files.
Wow. Okay. Yeah. I mean, it sounds like you've got
Some
to
are
have
old
some real
judgments.
right.
I mean,
Right.
but our firm is also was founded in 1930. So we have judgments that are decades old. Now you're probably wondering like why how could it be decades old? The statute of limitations on a judgment's 20 years in New York. Right. But if you make a voluntary payment, it resets the clock.
So what are you doing in those files? You just keep in touch with the debtor.
Yep, keep in touch with the debtor, keep looking for assets. We recently collected on a commercial case that was like 19 years old. We collected a small portion of it, 20 years.
Wow. That's pretty cool.
Yeah. So when you have a firm that's been around almost 100 years, we've got longevity and we've got a lot of repeat business with those clients. So I'm very lucky to that aspect of it, right?
Yeah. Yeah. All right. Sometime I got to make it up there. Check out your operation. Sounds
You
pretty
should, you
neat.
should. I have a YouTube channel where I do a tour of the building. We have a lot of fun things in the building. Um, so the whole idea is this: when we bought the building, we were renting a little suite, a little 4,000 square foot suite, and then as we outgrew it, we were looking for a place, and we bought this building. But the philosophy is this: if you go to like a fancy hotel, they have like the Montauk room or the Hamptons room, right? But if you go to typical law office, it's conference room A, conference room B, or something like I heard the other day was the front conference room and the back conference room. All right, but we don't do that. My law partner, she's like, "Come on, Tim, you're more creative than that. I'm more creative than that. Let's come up with something." So every room is themed. For example, like our walls are typically white, but we have one that's in the basement where the walls are gray, the furniture's black, the floor is dark gray, and it's got a 5 foot mural of the interior of the Batcave. So We've got a bat signal that's projected on the wall, a red phone in the middle. It's called the Bat Cave. So the rooms are themed. Still a conference room. Doesn't look like a 12-year-old boy's bedroom. It's not covered in toys like behind me, but that's the kind of fun stuff we do.
Wow. Okay. Yeah, sounds pretty cool.
Yeah. So when you're in New
Um,
York, you definitely come and check it out.
yeah, definitely will. So just in general with debt collection, definitely the agencies, the attorneys get a bad rap of just being, the debt collectors.
Yeah.
How do you respond to that public criticism? What's kind of your take on it?
So I do one of two things. One is I say, look, have you ever been on the end where you didn't get paid for your work that you did? How does that feel? Don't you wish someone could get that, help you get that? Right? I play it that way. Um, The other thing is, so my daughter, when she was in kindergarten, I mean, she's 17 now, but when my daughter was in kindergarten, my oldest daughter, she said, "Daddy, I went to school today and they asked, what does everybody do?" And she says, "You're a lawyer," and I didn't know what that meant. And someone thought it meant you put people in jail. Someone else thought that meant that you were breaking up families, like doing divorces. And I went, "No, no, 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 I don't do any of that." She's like, "So what do you do?" It's really hard to describe collections, right? It's really hard to describe business law to a 5-year-old. Like, yeah, I'm doing buy-sell agreements and doing operating contracts for LLCs. Like, she doesn't get that. So my response to her was, after thinking about it, we make people keep their promises. So when I have someone who's criticizing how come your collections, or how come you're a collection agency, or how come you're a collection law firm, when I hear that in the industry, I'm like, every single person we're going after made a promise at some point. Doesn't matter if they're a business or a consumer, they made a promise to do something, to pay something in exchange for that good or service they received. And now they're not fulfilling that promise. Why? What's the reason? Was the good not what they wanted? Was the service not right? Are they having a cash flow issue? Did they forget? Did they have a change in personnel who forgot to make the payment? What's the reason they didn't make that payment? If we can drill down to what that reason is, then let's get it paid. Or maybe our client screwed up, right? Maybe they sold non-conforming goods. We see that. We've seen that, right? UCC, non-conforming goods. Okay, great. We sold you non-conforming goods, but when did you tell us about that? This debt's been outstanding for 3 years, and this is the first you're telling us it was non-conforming.
Mhm.
So this is all a way to get to the end because, hey, you made a promise to pay. You made a promise. Now keep your promise.
Right. Yeah, it's a nice perspective. I mean, in our society, we're very much built on commercial relationships,
Right.
and that means they're enforceable.
Yeah. Yeah.
Yeah,
I would actually give you one more analogy, if I may. Well, not analogy, but another reason. When people say, "Oh, you're going after you're seizing people's assets, you're seizing this restaurant's assets," and I describe to them, "Okay, yeah, we sued a restaurant, we won, and we sent the sheriff or the marshal over to go seize the assets of the restaurant because they didn't pay for their food, the fish. So we represent a sushi provider, sushi grade fish, and so this fish company, this fisherman." Gets fish on a daily basis, uses a courier to deliver that fish to that restaurant. That restaurant then prepares it, sells it, and presumably makes a profit. And at the end of the month of this fisherman sending fish every week, if not every day, they get the fisherman sends an invoice. And that restaurant has promised to pay it at the end of the month. If they don't pay for that, now that fisherman can't pay their mortgage. They can't pay their kid tuition. They can't put food on their table.
right.
Right? So that's my response.
Yeah, yeah, I like that. All right, so how about just the war stories? What's the your greatest success?
Oh boy, I got a lot. No.
Well, how about your
um,
biggest? What was like your biggest claim that you were able to you know
so that
turn
was a copyright infringement case that we had. That was fun. It was an off Broadway or an on Broadway show that had hired someone as an intern. And that intern had become friends with the producers and the actors in the show. And they said, well, hey, we really like that piece of art that you made. Would you let us use it in the show? And my client says, no, I mean, I'd love to have you do it, but can I get paid for it? I'm just an intern right now. We'll make up a license or something. And the show basically said, no, no, just give it to us for free. We'll give you credit in the program. It's like, no, 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 no. I'm going to keep my piece of art. It was a sculpture. Um, he finishes his internship and leaves. And several years later, he gets a phone call from someone who's watching the show and says, hey, your sculpture looks great. What do you mean my sculpture looks great? How do you know it's mine? They gave put your name in the program. It was a very high profile show with locations in multiple cities across the world. And so we
Wow.
filed a copyright infringement lawsuit. And the argument that I made was each show, each performance was a new audience.
Mhm.
And as a result of it being a new audience, it's a new infringement. So it was, a nine-figure lawsuit. Now, obviously, that was way more than it would have been. It should not have been that much. There's a statutory provision for how much damages for copyright infringement. But that was one of my most favorite successes. I love that one.
And you prevailed.
Yeah, we prevailed. Well, the judge basically told the other side, if you don't settle, you're going to get a lot of bad press. And
Mhm.
you have damage. You have a reputational damage of now stealing an artist's work
Mhm. So they
and you're
settled it
admitting it
out.
in your program. You admitted it, so you better make a deal. And they did.
Oh.
And the artist, the client of mine, who actually was the boyfriend of someone I went to college with, that's how I met him. It actually helped pay for their wedding,
Oh, wow.
the the recovery. So they were able to get married. They were not married at the time. They were hoping to get married, but they wanted to have a nice wedding. And now, because of the payment, the settlement, the collection, they were able to have a beautiful wedding and invited me, of course. It was great. And they actually, at one point, they said, "Yeah, thanks to Tim. Without Tim, we wouldn't all be here right now at this beautiful venue, having this great food." And it was nice. It was a nice feeling. So that was one of my like feel good moments because again, we were representing the little guy against the big guy, right? In that case. But a lot of my clients are that. We tend not to represent credit card companies. We tend not to represent giant hospitals. Our clients tend to be mom and pop shops. Now, I'm not saying we don't have any larger institutions. We do, but our clients tend not to be those little tiny. Tend to be little tiny mom and pops. People who work hard. I would say about 75% of who we are representing the smaller businesses.
All right. Very cool. I actually really enjoyed this. Thanks for taking the time. Maybe we follow up another time.
Sure.
But so if people want to check out your firm, where can they
Yeah,
read about you?
so it's Smith Car Road, Smith, Smith Car Road, Carroad, Car Road, like car drives on a road. So smithcarroad.com. I'm also on YouTube, Instagram, and TikTok. The Real Tim Wan, the Real TIMWAN, and I do some fun stuff and crazy things on my social media.
All right, good stuff. And my firm is sandlerlawpa.com. I'm on YouTube at Sandler_law. If you like this episode, please like and subscribe. And thank you, Tim.
Thanks, Tuvia, for having me. It was fun.